Good afternoon, and welcome to the Employer Link webinar series presented by McAfee Taft. My name is Brad Neese, Managing Editor of Employer Link. Today, we will again be discussing the issue of same-sex spouses. Earlier this month, Oklahoma began issuing marriage licenses to same-sex couples after the U.S. Supreme Court left intact a federal court's decision overturning the state's ban on same-sex marriage. The trend is growing, and same-sex unions are now legal in a majority of U.S. states. As a follow-up to our After DOMA webinar presented back in January, we have reconvened a panel of McAfee and Taft attorneys to discuss and explain what the recent legalization of same-sex marriage in Oklahoma means for employers, including those with multi-state operations. Our presenters today are McAfee and Taft employee benefits attorney Jim Prince and employment lawyer Paul Ross, who is also leader of McAfee and Taft's Labor Employment Group. Moderating today's discussion is employment lawyer Charlie Plumb, who was also on our panel for the After DOMA webinar back in January. So with those introductions, I now turn it over to you, Charlie.
Thank you, Brad. One little thought before we get started. Go Royals. Now down to business. The law's approach to same-sex marriages has been changing rapidly, and in fact, it's almost changing on a weekly basis. So, employers as a group are faced with keeping up with and adapting to a big and rapidly changing area, including health insurance, retirement plans, and some other employment issues. So our webinar today is intended to help employers face this challenge, this changing workplace. And we want to start with giving you some understanding of what is the current law on the subject. We'll want to explain what issues you should be addressing right now. We'll talk about what we are seeing happening in the real world, that is how other employers are meeting and addressing these challenges. And then we hope to provide some insight on what we think you can expect and what you should anticipate in the future as an employer. And the starting point is really what kicked all this off, and that was the June 2013 decision by the Supreme Court of the United States. And that particular case, back in June of 2013, involved a same-sex couple that had been married in Canada, and they resided in New York, and New York law recognized that Canadian same-sex marriage. And the issue that came before the Supreme Court last summer in 2013 was whether federal estate tax laws, and I want to emphasize federal estate tax laws, treat same-sex couples the same as male and female couples. And the reason that was an issue was there was a federal law at the time, the Defense of Marriage Act, DOMA, that said governments were prohibited from recognizing same-sex marriages for the purposes of federal laws or programs. Again, I want to stress federal laws and programs. And what the Supreme Court said in Windsor in June of 2013 was, look, for purposes of federal benefits and federal entitlements, DOMA's exclusion of same-sex marriages was struck down. And it was struck down on a constitutional basis. Again, as to federal benefits and entitlement. That Windsor decision back in June of 2013 did not say states were required to recognize same-sex marriages, and the Windsor decision did not make sexual orientation or sexual preferences a protected class for purposes of our employment laws and discrimination laws. Now, 3 months after Windsor, that is in June of 2013, the Internal Revenue Service and the Department of Labor waded in, again, for purposes of federal laws and federal entitlements. And in September of 2013, the IRS and the DOL issued an advisory explaining that all same-sex marriages will be recognized regardless of the state of residence for purposes of federal tax, ERISA, retirement benefits, and that included COBRA issues and HIPAA. And that June 2013 advisory by the IRS and Department of Labor was retroactive to June 26, 2013. Again, this is with regard to those federal tax, ERISA, COBRA, and HIPAA issues. The DOL and the IRS also made clear that domestic partnerships and civil unions would not be treated the same as marriage. Now, we've had a more recent development, particularly for Oklahoma, with the Bishop case, and Paul, bring us up to speed with the significance and what happened in Bishop, if you would, please.
Okay, sure. So the Bishop case involved a couple that was that was living in Tulsa County and had hoped to be married. Two women that wanted a same-sex marriage in Oklahoma. They applied for a marriage license, and the Tulsa County clerk denied that request for a marriage license. They sued in federal court, arguing that the Equal Protection Clause of the United States Constitution was violated by a refusal to grant that license, and the federal court agreed and issued an injunction that struck down Oklahoma's laws prohibiting same-sex marriage. The 10th Circuit Court of Appeals then reviewed that decision, and in July of this year upheld that decision, striking down Oklahoma's law. And then most recently, here in the last 2 weeks, the United States Supreme Court decided not to overturn that decision, and therefore it is now final that Oklahoma's constitutional ban on same-sex marriages has been struck down and is no longer the law. The result of that is, in Oklahoma, now same-sex couples can be legally married. All counties have started issuing marriage licenses in Oklahoma, and it is now, and the point of today's conversation is to see what implication that new development has on the benefits laws and the employment laws that we're used to administering on a day-to-day basis. Now, what's further interesting about that is Oklahoma's recent cases are part of a growing trend. It's now the case that at least 30 states and the District of Columbia now recognize same-sex marriage through their ordinary state law system. There are appeal court rulings in 3 more states that are pending. We expect the same result with respect to those. And there's an additional 9 states that have judge-made rulings that will ultimately turn into the same striking down of rules similar to what Oklahoma had. So we see a trend of states being required by courts to recognize same-sex marriage. And the problem that we have with the current state of the law is that it is not the same in every state. Although we see that trend and we see that change in the law sweeping across the country, we still have a number of states that don't currently recognize same-sex marriages. And the problem that we have there is that many employers operate in multiple states, and that leaves them in a position where they almost have to have inconsistent benefit arrangements for different groups of employees that do the same job. We also have problems when employees relocate from one state to another. They may come from a state where same-sex marriage is recognized and move to a state where it is not. And that leaves employers in a bit of a state of limbo regarding what kinds of benefits they are required to provide when that change happens. And that will bring us at this point to our discussion of what the implications of Bishop are for Oklahoma employers. And at this point, I'll turn that presentation over to Jim for that discussion.
Thank you. Thank you, Paul. We are we're breaking up this discussion in terms of the workplace implications by talking separately about for-profit or private employers, including not-for-profit, private not-for-profit employers, and governmental employers. So let's take start with the implications on health and welfare plans with respect to the employers in the private sector. Now, neither the Bishop case nor the Windsor case nor any federal law, including the most recent Affordable Care Act, requires employers to provide spouses, either opposite sex or same-sex spouses, with health care or other welfare-type benefits. That's a different situation from retirement benefits, which we'll discuss a little bit later. But the key thing is that the federal law does not actually require. Now, if an employer does provide health care coverage to spouses, the law, these decisions, and the Affordable Care Act and other federal statutes do not expressly require that coverage be provided to same-sex spouses. Neither the Windsor case nor the Bishop case addressed either of those.
Okay, Jim, so I want to make sure because this is an important point, I think, here. Under retirement laws, there is a requirement that we provide benefits or provide for spousal benefits. But even with the advent of the Affordable Care Act, an employer can choose to not provide any spouses, same-sex or opposite sex, any coverage at all if it wishes.
That's correct, Charlie. In the area of retirement benefits, federal law, specifically ERISA and the tax code that applies to, and this applies to non-governmental employers, contains specific protections for spouses. For example, a spouse in a retirement plan has to be provided with a specific benefit and has to consent to any waiver of that benefit. That's not the case with health plans. There's not any specific protection for spouses in a health plan, other than the protection that the plan itself provides. For example, COBRA benefits and or HIPAA requirements.
Well, Paul, now understanding the point Jim just made, what about, as a practical matter, the issue as employers, whether they should be treating same-sex spouses equally for purposes of insurance? What issues are they facing now after Bishop, understanding Jim's point, the distinction between retirement plans and health insurance plans?
Right. So Jim's exactly right that none of the federal laws expressly require you to provide spousal benefits, and none of those laws define what a spouse is for you. So if you choose to provide spousal benefits, technically, under the federal laws that Jim's discussing, I guess you could define spouse in such a way as to only include heterosexual couples and not same-sex marriages.
And we're talking about health insurance plans.
Health insurance plans only.
Retirement. Okay.
But what we're concerned about here is that we think there is very likely to be a Title VII problem with that type of an arrangement. So if you decide to offer spousal benefits and you exclude same-sex spouses from that application of benefits, then we are likely to be in a situation where a crafty plaintiff's attorney is going to argue that that is a violation of the gender discrimination prohibitions in Title VII. Now, all of you that are listening here today are probably having the same initial reaction that I had in that situation, which is sexual orientation is not a protected characteristic under Title VII. Therefore, this distinction ought to be okay as far as Title VII is concerned. But there is a series of cases that has started gaining prominence over the last few years that are very good plaintiffs' attorneys getting around the sexual orientation problem in Title VII by crafting these arguments as gender discrimination claims. And the way they do that is to say that the employer is making decisions based on stereotypical gender roles in such a way that if I were a woman and I was doing this, then it would be okay. But because I'm a man and doing this, you're not okay with it as an employer. Therefore, this is a gender discrimination claim. And incidentally, we have already seen the first case filed that is going to make this very argument with respect to benefits. In the Western District of Washington, a district court case is pending right now. It's Hall versus BNSF Railway. We have a situation there where an employee with a same-sex spouse is suing under Title VII because same-sex health benefits are not being offered by that employer. The employer is offering heterosexual spousal benefits, but they are not offering same-sex benefits, and the suit was filed under Title VII claiming a gender discrimination case. And the employer immediately filed a motion to dismiss, claiming that this was a sexual orientation case, and therefore it's not covered by Title VII and it should be dismissed. And the court disagreed with that argument. This claim has survived the motion to dismiss. It's proceeding under a gender discrimination theory, and the case is going to have to be litigated now. The employer may ultimately prove that it is not gender discrimination, but the point is the sexual orientation barrier is not really going to be an effective defense for us if we decide to provide health insurance benefits to one group of spouses and not the other.
Okay, before we move to the question of governmental employers, I want to make sure we've captured really what Jim, you, and what you, Paul, are getting across. For private employers, when it comes to retirement plans, Jim, we have to treat same spouse couples the same as opposite sex couples, correct?
Yes, that's correct.
Okay. As to insurance plans, Paul, that's a moving target, but you're thinking that the future, particularly the way the trends are going, we're going to see, even though it's technically not required, we're going to see the same kind of approach. That is an implication that same-sex spouses should be treated the same as opposite-sex spouses for private employers when it comes to health insurance, even though that's not perhaps technically the case now.
Yeah, and I think the way I would phrase that, Charlie, is that the federal statutes do not expressly require it, but I think the ultimate result will be that Title VII does. If you choose to provide spousal benefits of one kind, Title VII is going to require you to provide them to both.
Okay. Jim, with that, can we move to the subject of our governmental employers?
Right.
And that's a little bit different.
Well, it is a little bit different. Again, federal law does not require state and local governments to provide spousal coverage. It does not expressly provide that. However, we've got not only the issue of the Title VII claim that may apply to a governmental employer, and I view that, Paul, in my own shorthand as if you have a male and a female employee, and they're both married to females. So you have a same-sex spouse and a opposite-sex spouse. Then and you don't provide coverage to the same-sex spouse, but you do provide coverage to the opposite-sex spouse. So you've got a male and a female who are both married to females, and you're not providing coverage for the employee whose spouse is not of the opposite sex. So you're treating them, those two employees, differently, even though they're both married to women. Right.
Now, Paul, you told us of the Title VII piece. What is additionally an issue for governmental employers?
So with respect to governmental employers, you have the additional burden of having to comply with the United States Constitution. So private employers don't have that direct problem, and so their only concern really in this issue is Title VII. Governmental employers have Title VII to worry about and the Constitution. And the same argument that was used in the Bishop case can be used to show that governmental employers are going to be required via equal protection to provide the same benefits to same-sex couples that they do to opposite-sex couples. And those of you that are governmental employers, you know, as we've seen through a number of different rights that are in the Constitution, you as an employer are required to provide constitutional rights the same as if you were acting as a governmental entity. So your employees have speech rights, your employees have search and seizure rights, they also have equal protection rights that private employers don't have. So you have a second level of concern in once you determine that you're going to provide some level of spousal health care benefits, you are very likely going to be required under both of these arguments to provide them to same-sex couples as well.
All right, so Paul, let me ask you this question. We've talked a little bit about what we see in the way of the trend when it comes to health insurance and same-sex spouses versus opposite-sex spouses. What if an employer called you this afternoon and says, I don't care about your prediction of the trend, or our prediction may be wrong. I want to treat, for purposes of health benefits or health insurance coverage, I do want to treat same-sex and opposite-sex marriages differently. How do you answer that question?
So my response would be, number one, my job is to provide you with what I think the law is. And then if you decide you want to make a business decision understanding the risk going forward that's different than that, you certainly can do that. But my advice would be that you should absolutely not do what you're proposing right there, because I am convinced, based on not only the trend in constitutional cases, but the trend in Title VII cases is going to be to recognize that is a discriminatory it's a gender-based discrimination that is going to violate Title VII.
And Jim, for your purposes, if I'm telling you for the purposes of retirement plans, I want to treat same-sex spouses differently from opposite-sex spouses, that's settled law. We can't do that, right?
We cannot do that for retirement plan purposes. It's not as well settled in connection with the health plan.
All right.
And Charlie, my experience is, I would say a majority of the employers who have considered the coverage of with respect to health care are probably leaning towards going with the path of least resistance and providing coverage to same-sex spouses in the same manner that they provide it to opposite-sex spouses. I say majority, and it's not the vast majority. There are employers who are saying, I'm going to wait and see if the government comes out with something specifically addressing this, or I'm going to roll the dice with respect to this potential discrimination claim. Okay.
Now, I think we've already addressed that slide. Brad, if we go to the next slide, please. Jim, what about the issue of applicable taxes of health benefits?
Well, yeah. Generally, employer-provided health care is not taxable to the employee, and that, at least for federal purposes, that's been made clear that exclusion applies both to same-sex spouses and to opposite-sex spouses. What hasn't been clear is whether states will recognize that exclusion. Now, a number of states, including Oklahoma, piggyback off of the federal system, and for them, it seems like they're going to have to recognize the federal rule. Other states may have to address it directly. Now, those states that are taxing a benefit that's provided to a same-sex couple, where they are not taxing it to the opposite-sex couple, would face, I think, the equal protection argument and claim that Paul has talked about.
Okay, so for purposes now of an Oklahoma employer, after the Bishop ruling that Paul talked about, is a same-sex spouse going to be treated the same for purposes of taxation or health benefits?
The Oklahoma Tax Commission hasn't come out and said that. It seems to us that should be the result.
Okay. Now we've been talking about health plans quite a bit. Let's switch gears, and Jim, can you talk a little bit about retirement plans and where they stand?
I can, and some of this is a reiteration of some of the material that we talked about earlier this year on the DOMA, and for tax qualified retirement plans that are subject to ERISA, and that is generally all private employers. All spouses have to be treated the same. That same-sex spouse has to be treated as the same as an opposite-sex spouse, i.e., a spouse is a spouse, and for that purpose, the marriage is based on the state of celebration. So for these purposes, it doesn't matter where the couple resides. What matters is where did they get married. And if their marriage was legal, if they have a legal marriage in the state where they celebrated it, then for federal tax-qualified retirement plan purposes, they have to be treated as spouses and have all of the rights that I mentioned earlier that relate to spouses. That includes the right to be a beneficiary under the plan, the right to be able to receive distributions of benefits at a minimum amount. The spouse has to be guaranteed a specific amount of the benefit that's available to the participant. They have to be able to, on divorce, receive a court-ordered portion of the benefit that has been earned by the employee participant. So there's a number of issues there and those are fairly clear. What has not been as clear is how the governmental plans will be treated, because as we mentioned, the DOMA case really did not, the Windsor case and DOMA did not directly apply to these governmental plans. But now that we have, at least in Oklahoma, we have these decisions that say that treating same-sex spouses differently from opposite-sex spouses violates equal protection, then our governmental plans are subject to that kind of an argument. And so to provide a benefit for a same-sex spouse that is not, for an opposite-sex spouse that is not provided to a same-sex spouse would open the plan up and the employer to an equal protection type claim. Now, governmental plans are not subject to the same specific requirements that the non-governmental plans are, but whatever benefits that they provide to opposite-sex spouses would need to be provided to the same-sex spouses, or face the potential claim that there's a violation of equal protection.
So the same kind of trend that Paul was addressing then.
Exactly.
Okay. Exactly. Well, what about a little bit of a checklist, perhaps? What would you tell our employers they should be doing right now with regard to either health plans or retirement plans?
Well, certainly on the retirement plan side, they should have, or should be in the process of addressing that. If the plan defines a spouse in a way that would violate what we talked about. So if the plan says, for example, that spouse means a husband and wife, someone that is married to the opposite sex, then that plan definition needs to be changed, and the change needs to happen prior to the end of this year.
So if I'm an employer, an HR professional, I should be looking at my plans in the definitions, perhaps section, or in the eligibility sections on how we define who's a spouse and who's eligible.
Exactly.
Okay.
Now, and that's on the retirement plans. For health plans, again, it depends on what the employer decides to do. But if the employer decides to cover same-sex spouses, then the employer will need to check the definition of spouse in the health plan document to determine whether that the definition that's in there is consistent with what the employer intends to do.
And we know that all these benefit laws have as an element getting information in the hands of the workforce,
sure.
the participants, not just the employees, but their beneficiaries as well. So what in this process, if I'm looking at what my current plans have in the way of eligibility or definition, and I decide I want to change it, or I feel like I need to change it, what is the concomitant obligation towards my employee?
Well, I think it's at some point they're going to need to notify employees, particularly where new benefits are being provided, that they are available to them. Now, the requirement, at least on health plans, is going to be fairly quickly, because most plans have open enrollment toward the end of the calendar year. And so if they're changing their definition of spouse and are going to include or same-sex spouses where they didn't before, then that's going to have to be communicated probably as part of their open enrollment materials. In addition, any form of summary plan description will need to be amended. That can be done retroactively, but it's still going to have to be addressed.
And the timeline for those kind of changes to plan documents? Yeah.
Now, the changes to plan documents, there's not a specific, other than the retirement plans that have a definition that excludes same-sex spouses. The plans with those definitions have to be amended by the end of this year, by the end of 2014. health plans and other welfare benefit plans don't have any specific requirements that, and the government has not issued any guidance in terms of when they need to be amended. But they do need to be, if a change is being made, that's got to be communicated. The summary plan description requirement is actually fairly retroactive in that it does not have to be done until I think it's the 15th day of the 7th month following the year in which the change is made. So that they've got plenty of, they're changing a definition now in their health plan. But nevertheless, notwithstanding that extra period you get to change your SPD, your enrollment materials are going to have to be changed. Because you're going to have to notify your employees that their same-sex spouses are eligible, if that's the decision that the employer makes.
Well, and I know from a lot of our own experiences, a lot of our employers are getting questions right now from their workforce. So that's a really good opportunity to say, look, we've had these kind of questions, and we thought we'd give you right now some new information and clarify exactly who's going to be covered by our retirement plan, who's going to be covered by our health plan. It's a good opportunity to address that. I got a question for you before we move to general employment law considerations. In the past, in the context of retirement plans and health benefit plans, we've sometimes found ourselves dealing with civil unions or domestic partnerships that have been recognized in other states. What is the effect of these new decisions and the trends we're talking about? Where do we stand as employers with civil unions and domestic partnerships?
Well, for federal law purposes, a civil union is not the same as a marriage. So a person who is a party to a civil union is not a spouse. Now, some employers have provided benefits to employees and their civil union partners, and that could continue. But the person that's a party to that civil union is not a spouse, so they don't have the same rights that the spouse has. For example, going back to the retirement plan, they don't have the specific protections that spouses have in retirement plans. In addition, particularly in the area of taxation, a civil union partner is not a spouse, and therefore the benefit provided to that civil union partner is a taxable benefit to the employee on whose behalf that benefit's provided.
Well, and this leads to an interesting point. I think we've dealt with employers who have chosen to recognize civil unions and domestic partnerships, and have even included that kind of language in their plan documents. Those employers might want to look at some transition period where they're explaining to their employees, if you're in a state that now recognizes same-sex marriages, realize and understand now that we're recognizing same-sex marriages, our plan documents are going to recognize that, and you may need to go get married in order to benefit from some of the plan benefits you're talking about and to avoid taxation.
Right. And employers may be changing their position on providing benefits to people who are not married but are part of a civil union, for example.
Paul, let's change gears now and let's talk about some just general employment law considerations apart from the retirement plan and the health insurance pieces.
Right. So the main topic that we want to address as far as implications from the Bishop case is what the impact is on the Family Medical Leave Act and the requirement that we provide benefits, particularly to spouses of employees or employees who have spouses that have serious health conditions. So when Windsor was first decided, the DOL immediately issued some guidance making it clear that it was the Department of Labor's position that spouses in same-sex marriages should be considered for the purposes of the Family Medical Leave Act in states where the employee lived in a state that recognized same-sex marriage. So the initial rule that was published by the Department of Labor was that the state of residence was the state that mattered. That is not the same rule that the IRS uses now. The IRS uses a rule that is based on the state of celebration. If the marriage was valid in the state where it was created, then for IRS purposes, that marriage is recognized everywhere in the country. But that's not the case for the Family Medical Leave Act. So there's two things that we need to discuss today. First, the Bishop case now means that Oklahoma is a state where same-sex marriages are recognized. Therefore, employees now can take Family Medical Leave Act for issues related to a spouse when we could not in the past. We are now a state where if our employees reside in Oklahoma, that law is now recognized. So there is now some expanded liability for you, expanded opportunity for employees to take qualified Family Medical Leave Act for serious health conditions dealing with their spouses. In addition to that, there is a new regulation pending that the Department of Labor has published and has accepted comment for that would change the Family Medical Leave Act rule to be similar to the IRS's rule. That means in the very near future, and it could be approved any time, in the very near future, family medical leave benefits are going to have to be extended to employees with same-sex spouses no matter where the marriage was created and regardless of where they live. So all same-sex marriages that are valid under some state's law are going to be recognized across the country. I don't have any reason to believe that that regulation will not pass. The comment period is closed on that, and I expect to hear something on that any time now. But either way, this Bishop decision does impact your employees that live in Oklahoma.
So, Paul, a takeaway from post-Bishop and the FMLA, I'm an employer, I'm an HR professional, I need to go look at my FMLA policy and make sure I've defined spouse in my FMLA policy to encompass same-sex spouses.
That's correct.
Okay. What about other employment policies or other employment issues?
Right. So we went through and did quite a bit of brainstorming after the Bishop case to try to identify policies and procedures that might be impacted by that decision. And it turns out that at least in the general employment field, there probably aren't a lot of them. But there are, particularly in the area of benefits that you might be offering employees that aren't required by statutes. So let's take, for example, a bereavement policy. You may have a bereavement leave policy that allows your employees to take 3 to 5 days off when there is a death in their family that is, within some specified level of close-knit family. So it may be for spouses or children or parents, some limited group of people that will qualify your employees for a bereavement leave. In the past, that definition probably did not include same-sex spouses. It probably should include that now. If you're providing a benefit that is for spouses of your employees, you should probably make sure that your policy does not exclude same-sex spouses. And again, it's not because there's any requirement that you provide bereavement leave to anyone. It's more that if you decide you're going to provide a benefit to one group of people, Title VII is very likely going to require you to provide that same benefit to same-sex couples as well.
And so does that same thinking you've just described, Paul, apply to other forms of leave? And I'm talking about non-FMLA leave. Let's say I've got a PTO policy or something like that. Would that same thinking apply?
I think it does. I think it applies in any context where you have a policy that in any way touches on a spousal relationship. And a number of employers don't have any. And so there may not be any particular changes that you need to make. However, I think you do need to think about your policies and practices, particularly with respect to where you place the limits on those policies and procedures, and make sure that you're not artificially distinguishing between one set of spouses over another.
So one thing I might do, again, if I put on my employer or HR professional hat, I might pull my handbook out or my policies and do a word search for wife, husband, and spouse and see what kicks out and see how I've expressed that or how I've defined that.
That's right. And then I think beyond that, it probably bears a conversation with your particular human resources attorney about what level of risk you're willing to take when it comes to implementing policies the way they are or making changes.
Okay, now we said at the outset, one of our goals today was to provide our listeners with some predictions or some identification of trends. Paul, that's in your bailiwick, okay?
Yeah, so, I mean, we've talked quite a bit about that today, and the point is a pretty clear one. I mean, it is correct to say that Title VII does not protect sexual orientation as a protected characteristic. However, the trend is, and most federal courts are acknowledging these cases, is to treat what would otherwise be a sexual orientation discrimination case as a gender case. And those cases have been successful, at least at surviving motions to dismiss, surviving summary judgment motions. And so it then becomes a jury question, and it will ultimately depend on, as always, what jury is picked as to whether or not that case is successful. So those cases are out there. I think we will continue to see those more and more, particularly against employers that decide to offer a spousal benefit for opposite-sex couples, but try to exclude that benefit for same-sex couples. The other thing that we are still likely to see is Congress could decide to deal with this issue by amending Title VII. Those of you that have heard me speak in the past, I've said for a couple of years now that I think it's only a matter of time until it will be a part of federal law that sexual orientation is a protected characteristic under Title VII. Every single year, the amendment is proposed. It's called the Employment Non-Discrimination Act. That amendment is reproposed every year when Congress session starts. It will be proposed again this year, and the likely result of whether or not it passes this year will depend on how the elections go. But this is, again, something that we need to keep an eye on because all of the discussions we've had here today become moot if the Employment Non-Discrimination Act is passed and sexual orientation becomes a protected characteristic under Title VII.
And, one thing in terms of a kind of a day-to-day observation we have dealing with employers, I think the distinct trend we're seeing, particularly with larger employers and multi-state employers, is a trend because of what Paul's talked about and some practical considerations to extend the same types of benefits to same-sex spouses as opposite-sex spouses. I mean, what I hear from a lot of employers is, look, I don't want to be telling my workforce that the benefits you're going to get or the benefits you're entitled to, whether it's leave or health insurance, is going to be dependent on where you live. I want to treat everybody as much as I can the same. I'm hearing that, and I'm also hearing the administrative nightmare of trying to administer leave programs or health insurance plans differently across my workforce depending on where they reside. Paul, what's been your experience on those?
I have heard the same thing. The administrative burden when you start talking about the place of residence essentially requires your human resources staff to know the law of all the states within which you operate and keep track of all the developments that are occurring almost daily when it comes to court cases on this particular topic. And so given the relatively small number of people that are impacted by this, a lot of the employers that I've dealt with have basically decided that for administrative purposes, it just makes sense to treat everyone the same, regardless of whether or not the law requires them to do so.
Okay. Jim, when we talk about tax issues and ERISA, my head explodes. So how about taking us through some bullet points, kind of a takeaway for retirement plans and health insurance plans first, for non-governmental employers, and then finish with governmental employers. So we've got it all capsulized for everybody, please.
Charlie, we were anticipating your head exploding,
okay.
So we have the slides ready for you. Yes, really the takeaway on and we've broken it up into non-governmental versus governmental. For non-governmental retirement plans, keep in mind, first of all, that everyone who is legally married, who is a legally married spouse, must be treated the same for retirement plan purposes, and that now marriages between persons in Oklahoma of the same sex are now legal. And then an additional takeaway, what I've mentioned previously, is look at your plan document to make sure if you've got a definition of spouse that would be violative of what we've talked about here today, make sure you get that changed prior to the end of the year. In the health and welfare arena, again, there are no express requirements to provide benefits to same-sex spouses, but you are opening yourself up to these discrimination claims that Paul has discussed in a fair amount of detail.
How about our public or governmental employers?
The governmental employers, and particularly those in Oklahoma now, have to recognize that same-sex couples can be legally married in Oklahoma, and that although they are not subject to the same type of requirements in terms of their retirement plans, and are also not subject to any specific requirement related to health and welfare, they are subject to the requirements that they treat employees equally under the Equal Protection Clause of the Constitution. So, if they're treating same-sex couples differently from opposite-sex couples, they need to be at least mindful that there's that potential that an employee can bring a claim based on the Equal Protection Clause.
And so for governmental employers, that observation applies to both retirement plans and health insurance plans.
It does, equally.
Okay.
I want to thank Jim Prince, Paul Ross, and Charlie Plumb for presenting today's webinar. And on behalf of the law firm of McAfee Taft, thank you for joining us for another Employer Link webinar. See you next time and have a great afternoon.